Okay, if a judge knowingly, willingly violates the Code of Judicial Conduct, I just did a couple shorts, so I'm going to put them together for you. When a judge knowingly and willingly violates the Code of Judicial Conduct, they can face serious penalties ranging from formal reprimands to removal from the bench, while judges enjoy absolute immunity, judicial immunity from civil lawsuits. For their official decisions, their ethical violations are handled by specific oversight bodies. You might want to file a formal complaint with appropriate disciplinary body. Federal judges file a complaint with the clerk of appropriate U.S. Court of Appeals under Judicial Conduct and Disability Act. State judges contact the state's oversight agency. All you got to do is Google the Rules of Professional Conduct and the Rules of Professional Conduct complaint form, and that'll tell you exactly the Code of Judicial Conduct and the Code of Judicial Conduct complaint form, and that's self-explanatory. Attorneys, lawyers are typically bound by the professional rules of professional conduct that legally mandate them to report known judicial misconduct, and they don't do that. No, if you read the rules of professional conduct and the Code of Judicial Conduct, they're self-explanatory. You'll understand them as easily as I did. Okay, so anyway, so they knowingly and willingly violate the Code of Judicial Conduct. So that was just okay. And lawyers are notorious for violating the rules of professional conduct. When a lawyer knowingly and willingly violates the rules of professional conduct, such as engaging in fraud, lying to a court, or stealing a client's funds, they are committing professional misconduct. This subjects them to serve disciplinary action, civil liability, and sometimes criminal charges. It's a federal charge known as deprivation of rights. Attorneys are regulated by the state disciplinary bodies. For example, if a lawyer practices in Illinois, such as Hickory Hills area, they fall under the jurisdiction of the Attorney Registration and Disciplinary Commission. The investigation, the IRDC investigates grievances and will recommend formal charges of evidence of knowing that violation is found. The penalties. The Illinois Supreme Court ultimately determines the appropriate penalty. Punishments range from public or private reprimands, suspensions, losing the right to practice for a set period of time, or disbarment, permanent loss of license. Court sanctions. If the violation occurs in the middle or ongoing litigation, judges have the power to penalize a lawyer directly. Contempt of court. A judge can fine the attorney and order temporary jail time for willful disobedience of courtroom misconduct. Case dismissal. Evidence suppression. The court may rule against the lawyer's client, strike pleadings, or bar evidence entirely as a result of discovery abuses or ethical violations. Frivolous filing sections of Illinois courts operate under Supreme Court 137, which allows a judge to order the violating lawyer to pay the opposing party's attorney fees for filing baseless, dishonest, or bad faith documents. Civil and criminal liability, legal malpractice, and the intentional ethics violation cause financial or legal harm to the client. The lawyer can be sued for legal malpractice. Criminal charges. Certain unethical violations such as stealing client settlement funds, forfeiture, theft, binding a witness, or forging documents cross the line from ethical violations to actual crime, leading to felony charges and imprisonment. Loss of reputation and employment. Lawyers who commit severe ethical violations frequently get fired from their law firms, lose their malpractice insurance coverage, and face permanent damage to their professional reputation, rendering them from largely unemployable in the legal field. Okay. When a lawyer and judge collude to violate ethical codes, it undermines the integrity of the judicial system. Attorneys and judges are strictly bound by independent and ethical guidelines, such as the ABA Model Rules of Professional Conduct and the Model Code of Judicial Conduct, which specifically prohibit assisting, encouraging, or engaging in corrupt or prejudicial conduct. Common ethical violations and collusion. When legal professionals and judges work together to subvert justice, it generally manifests through a few common mechanisms: prohibited by ex parte communications, attorney communications privately with presiding judge about the merits of a pending case without the opposing counsel present. This is direct violation of both Judicial Canon 2 and the rules of professional conduct. Quid pro quo and favoritism, exchanging special personal considerations, favors, and undisclosed close relationships for favorable judicial rulings. Failure to report. Both judges and lawyers have an affirmative mandatory duty to report misconduct. If a judge or attorney witnesses unethical behavior and hides it, they violate their respective ethical codes. Consequences and remedies. Collusion between a lawyer and judge goes beyond administrative rule violations and can escalate into criminal conspiracy, fraud, and obstruction of justice. Here's how these violations are addressed. Lawyer Disciplinary Board. In Illinois, the Attorney Registration Disciplinary Commission investigate and prosecute ethical misconduct by lawyers. Violation of the rules professional conduct can result in sanctions ranging from reprimand to disbarment. Judicial Inquiry Boards. Allegations of misconduct by judges are handled by state bodies such as the Illinois Courts Commission or the Judicial Inquiry Board. They have a power to reprimand, suspend, or remove a judge from the bench. Appellate review. If a lawyer or judge's action prejudices the outcome of a case, they adversely affect the party can file an appeal to have tainted judgment overturned. Okay, when a lawyer and judge... So, what you're dealing with is a conspiracy against rights under the color of law. You start with your lawyer for violating the rules of professional conduct knowingly and willingly, and it'll be easy for you to understand if you pick up a copy or just Google it, the rules of professional conduct, and you'll see that they knowingly and willingly decided they weren't going to do that. Now that's misconduct, and it's the legal obligations of all lawyers and judges. The opposing party and the judge should have cited your attorney for ineffective assistance as counsel for his unconstitutional actions of violating the rules of professional conduct knowingly and willingly. Okay, but they didn't report that misconduct. And as I read to you, reporting misconduct is mandatory in both the rules and the codes. And nobody reporting that misconduct is misconduct, creating a conspiracy against rights under the color of law, which is known as deprivation of rights. Okay. See, you know, they're taking advantage of your ignorance of the law. Quite simply put it, conspiracy against rights is a federal crime that occurs when two or more people conspire to injure, oppress, or threaten to intimidate anyone in the exercise or enjoyment of their constitutional federal rights. When these actions are committed under the cover of law, it means that the perpetrators are utilizing their official authority, actual or apparent, as a government officials such as police officers, prison guards, or judges to willfully deprive someone of their rights. And they're not citing your attorney for ineffective assistance of counsel as deprivation of rights because they took the oath. And the oath is required in the Code of Judicial Conduct if the judge knows of any attorney or any judge violating the rules of professional conduct or the Code of Judicial Conduct to report those violations, and that judge didn't, thus creating conspiracy against rights under the color of law. Not too hard to understand if you just read the rules and the codes. Okay, it's conspiracy against rights. That's them working together to see to it that you didn't have effective assistance of counsel. If you didn't have effective assistance of counsel, you didn't get a fair trial. If you didn't get a fair trial, due process simply did not exist. Makes it lawful for two or more to conspire to interfere with rights protected by the U.S. Constitution. Penalties include fines, imprisonment, a death penalty, or life imprisonment if death, kidnapping, or aggravated sexual assault. Deprivation of rights under the color of law makes it a crime for any person acting under the authority of law, even if they abuse or exceed that authority, to willfully deprive someone of their constitutional or federal rights. Punishments range from fines, short prison terms, to life in prison or death penalty, depending on the severity of the offense. The Federal Bureau of Investigation is the lead federal agency responsible for investigating color of law abuses and civil rights violations. Violations the FBI typically investigate include excessive use of force, sexual misconduct, unlawful arrest, theft, and systematic discrimination. Okay, so it's easy to understand the rules, the codes. Just going over it with somebody the other day, and I had him open it up and read it to me. He didn't believe he understood the law until I had him open it up and read it to me. And he started reading it. A lawyer is a member of the legal profession, is a representative of clients and officer of the legal system, a public citizen having special responsibilities for the quality of justice. Showed him that's about as hard as it gets. And the more he read, the more rambunctious he became about his reading. He went from slouching to sitting up straight, from talking slowly and softly to proudly and loudly. Lawyers' conduct should conform to the requirements of the law, both in professional service to clients and lawyers' business. So I told him, hey, just click over here and read this. Read what it says for competence. The lawyer shall provide competent representation to a client. Competent representation requires legal skill, knowledge, thoroughness, and preparation reasonably necessary for that representation. He said, well, how do you know what's reasonably necessary? I said, well, you go through the rules, and it'll tell you. Okay. Scope of representation, allocation of authority between client and lawyer. A lawyer shall abide by a client's decision concerning the objectives of representation as required by Rule Point 4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client is implied authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter in a criminal case. The lawyer shall abide by the client's decision after consultation. And see, he's working, he's got a lawyer for this probate court thing and going, and I'm explaining to him that this isn't happening, and it's easy to understand if you just read it your damn self. Diligence, Lawyers shall act with reasonable diligence and promptness in representing the client. How hard is that to understand? That's the law. Okay? These are laws here. Your constitutional rights. They took the oath to do this, so that makes these your constitutional rights. This is what gives you effective assistance of counsel. Okay. So he said there's different things he's got going on in courts. I said, so well, you're going to want to use different laws. You won't use all of these in the same court, but you will use these in every court. And so you're finally deciding, or understanding. He was saying his brother had an argument with the lawyer and something about quitting, firing, whatever. So I told him to look that up. Or declining, terminating representation, advisor. Representing client, lawyers shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law but other considerations such as moral, economic, social, political factors that may be relevant to the client's situation. Okay, meritorious claims and contentions. That means no lying. You got to come with truth. You got to come with facts. Evidence. Okay. Special responsibilities of the prosecutor. I helped them have a case dismissed on that. There was no probable cause to proceed, so they threw the case out. I told them truthful statements to others. They violated that. They dragged the case on, and they eventually threw it out because he didn't take the deal and kept pushing for a trial and started complaining about the violation of the quick and speedy trial or something like that. So he said they just let it go. They threw it out. They dismissed the case. But see, they violated all this to do that to him, and that was just to trick him into taking a plea. So they got a little mark on their record saying, hey, I'm locking up criminals, or being tough on crime. But they were just tricking him into accepting an X on his back for there was no probable cause. There was no probable cause for arrest. And then they exceeded the quick and speedy trial limits by like 5-6 months. And that was just trying to convince him to take the plea. Okay, but all you gotta do is click and read. Click and read. Alright? It's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, and only assist or induce another to do so through the acts of another. I mean, that's not hard to understand. And then it says here, reporting misconduct. Lawyer knows another lawyer has committed violation of the rules of professional conduct, has to report. Lawyer knows that a judge has committed violation of Code of Judicial Conduct, has to report them. See, and nobody's doing any of this, okay? So you can go to the rules or the codes, it'll tell you the same thing. It'll be just as easy. Alright? This is the one I always use because they don't like to let you talk. Or 2.15, right? I'm sorry. Oh, here it is, ensuring the right to be heard. He kept getting shot down. Everybody gets shot down, but that's your constitutional right, and they took an oath to do that. When they deprive you of a right to be heard, that's a lack of competence, diligence, cooperation. Okay, it shows bias, prejudice, and harassment. Impartiality is the lack of, and the lack of fairness. Giving precedence to the duties of judicial office would mean doing all this. So it's impossible to violate, one code without violating multiple codes. Okay, so that was disqualification there. That falls under disability and impairment. Responding to judicial and lawyer misconduct, okay? That's so hard to understand. Judge having knowledge that another judge has committed violation of the code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge, and other respects shall inform the proper authority, and the same goes if they know about lawyers. If you violate Canon 2, then you wind up violating Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and avoid impropriety in the appearance of the propriety. Rule 1.1, competent compliance with the law. Judge shall comply with the law, including the Code of Judicial Conduct. How hard is that to understand? They'll tell you ignorance of the law is no excuse, but how about ignoring the law? Ignoring the law, that's a federal crime. And they're ignoring every law in the court of law. Promoting the confidence in the judiciary. Judge shall act in all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Well, that ain't happening, is it now? Avoiding abuse of prestige of judicial office. A judge shall not abuse the prestige of judicial office to advocate the personal economic interest of the judge or others, or allows others to do so. Okay. So violate Canon 2, bunch of rules there, and then they violate Canon 1. Okay. And then you want to go to the preamble and the scope. And see, an independent, fair, and impartial judiciary is indispensable. See, so you're going to want to use some of the dialogue here in the preamble and the scope when you cite them for violating the Code of Judicial Conduct, and it's not much, but a lot of good citings here, a lot of good things to quote. Okay, so it's pretty easy to prove violating the Code of Judicial Conduct, violations of the rules of professional conduct. It's easy to prove, conspiracy against rights under the color of law, because it's mandatory to report misconduct. Nobody reported misconduct, but the only reason nobody reported misconduct because everybody does it all the time. So, I mean, it just, hit one, they all go down. It's a house of cards. But as you can see, all this is supposed to happen at the very beginning, what's in the Rules of Professional Conduct and the Code of Judicial Conduct. So from day one, you were deprived effective assistance of counsel, fair trial, due process, because none of this happened. Nothing happened in the Rules of Professional Conduct, Code of Judicial Conduct. So anything beyond that is nothing but legal harassment. It's to intimidate you, And if you read that conspiracy against rights under the color of law, again, you'll see that everything they did is illegal. Okay, thank you, and good night. May your Creator always be with you, and may many blessings. I wish you nothing but a long life and good health.